All right, perfect. Welcome, everyone. So today we're going to do a review of the business law textbook. We're going to do chapters 18 and 19 today. So that's going to be our main focus. And if anyone has any questions, please don't hesitate to type in the chat box and I can explain everything in greater detail. So let's begin. Okay. All right, perfect. So we did chapter 17, legal assent, yesterday. If you guys need to go back and watch, it's up on the YouTube channel. I'll make sure to send over a link. But now we're going to do chapter 18. So this is regarding contracts and writing. So let's begin. Okay, good. Screen is being shared. Perfect. Okay. So as you guys could probably assume, written contracts are going to provide certain advantages compared to oral contracts, mainly due to disputes about terms, such as material terms and negotiable instruments are also helpful with written contracts. So the first thing we have is a statute of frauds. So all this is, the first thing that it does, it eases contractual negotiations by requiring sufficiently reliable evidence to prove the existence and specific terms of a contract. So for example, let's say we enter a contract to sell wallets. Here's my wallet, for example. We enter a contract to sell wallets to to Walmart, right? So with Walmart, we're going to fulfill the first part of the statute of frauds, which means that we put in the contract all the material terms and we make sure they're definite and certain. So by having the contract in writing, nothing can be disputed when we both sign off on it. Okay, so that's the first part. The second part is going to be to prevent unreliable oral evidence from interfering with the contract or relationship. So maybe the judges or attorneys or whoever might be involved, let's say they're not at the negotiation. One second. Okay, so let's say they aren't at the negotiation table. People can say whatever they want. Let's say we agreed, hey, we're going to give you 1,000 wallets a month. You're gonna have to pay $2 per wallet. So it's going to be $2,000 a month that Walmart is going to pay us for the inventory. Let's say, hey, Walmart agreed to pay us $4,000 a month. Well, if we don't have the contract in writing, we could say that, but if we have it in writing, it's going to be a lot harder to prove that because the writing is there. So that's going to prevent the unreliable oral evidence from interfering with a contract or relationship. And then the third main purpose is to prevent parties entering into contracts which they don't agree. So let's say, for example, someone said, hey, I'll give you this amount of data for X amount of dollars. And let's say I agreed to it because I didn't know better, or it was just a knee-jerk reaction. I didn't really think about it. That would fall under preventing party from entering a contract which they didn't agree. So let's say we didn't want to pay for the data, but we said it because we felt pressured to do so, or we were under duress or something like that. We would have the contract in writing, which means we would have more of an opportunity to review the terms and conditions of the contract. And as a result, we would be protected under statute of frauds. So the main three things for the statute of frauds, why it exists, it ensures that the terms are going to be, first of all, exist and that they're going to be specific. Number two is that we're going to prevent unreliable oral evidence, so blatant lying. And then number three, we're going to be able to prevent ourselves from entering contracts which we don't agree. All right. So only specific types of contracts within the statute of frauds. So there needs to be contract whose terms prevent possible performance within a year, promises made in consideration of marriage, contracts for one party to pay the debt of another if the initial party fails to pay, and then contracts related to an interest in land. So, for example, let's say let's do the fourth part. So, if we want to purchase a house, the company that sells the house, or let's say better yet, the seller of the house, they will enter into a purchase agreement with you. It's also known as an LOI. I'll show you guys what an LOI is. LOI It's a letter of intent. So it means it's a document outlining the understanding between two or more parties which they intend to formalize a legally binding agreement. So they'll get into an LOI and a sales contract. So that will be an example of a contract that falls under the statute of frauds for a sale of land. Okay. So let's say let's go to the first part. So contracts whose terms prevent possible performance within 1 year. So let's say, for example, Roberta is a good example. He goes into a contract with Elise to work for her for 1 year starting October 1st. If the contract's created on the preceding September 15th and cannot be completed 1 year from September 16th, it has to be in writing. So let's say, for example, we sign a contract for employment and we agree to start next year. So let's say, hey, we agree to start working for you on August 2nd, 2025. So that would have to be in writing under the statute of frauds. Okay. All right, let's keep going. So I think you guys, everyone knows what a prenuptial agreement is. It's a prenup. It's basically an agreement which two parties enter to perform marriage that will state the ownership rights each party enjoys in the other party's property. So if you guys ever heard the phrase, you probably have heard it before, sign a prenup, sign a prenup. Well, basically it will outline in a contract what party owns which. And then in the divorce, if there is an eventual divorce, it will make it a lot easier to split assets. So that would be a prenuptial agreement, very common in divorce law. So if we wanted to do something, so let's say I will give you this ring in exchange for marrying me, we don't have to put that in writing. But if we say, hey, if we get divorced, or in the case of anything that happens, you will get 50% of my assets. That, and let's say that has to be in writing in a prenuptial agreement. Okay. And then we have contracts for one party to pay the debt of another. So this does happen. So there is secondary obligation or collateral promises. Collateral, if you guys don't know, it's basically when someone puts up something or they put up some type of asset that can be used to be sold off in order to cover the losses from the loan. So for example, if your parents have a mortgage right now, they put the home up as collateral if they didn't pay the mortgage. So if they are unable to pay their mortgage and they foreclose on the property, the lender can seize the home and sell the home in order to pay off the remaining loan. So that would be what collateral is. So let's say, for example, we enter into a contract for a home. So let's say I buy a house, and I get a loan from TD Bank. Now, let's say on the loan, I put in a secondary promise stating, hey, if I'm unable to pay the loan, that my Aunt Sally has to pay my debt. So that promise would have to be in writing because it's a secondary obligation. So let's say if Jared fails to pay the promissory note to TD Bank, um, Aunt's Jared Sally, uh, Jared's Aunt Sally, excuse me, is responsible for paying the loan. Now, if we had a primary obligation, let's say we didn't have her, let's say it was just me, stating if Jared is obligated to pay a loan in monies of 500,000. Let's say the home is worth. Let's say it was worth 600,000. We put 100,000 down. That would be the primary obligation of me having to pay. Okay. Okay. Keep going. So we also have the equal dignity rule. So all this means is that contracts that would normally fall under the statute need a writing if negotiated. A principal must be in writing if they're negotiated by an agent. So let's say Luke appoints Sanjeev. Let's say Sanjeev is his lawyer. And let's say Sanjeev enters an agreement for Luke with Carrie that cannot be completed with 1 year according to the terms. So if Luke contracted directly with Carrie, the agreement would be within the statute required a writing. However, with Sanjeev's contract, which is on the behalf of Luke, must be in writing according to the equal dignity rule. So if you have a third party represent you, let's say an attorney or a business consultant or someone like that, even if it's not you directly signing the contract and it's on your behalf, you still have to put it in writing under the equal dignity rule if the contract and its obligations cannot be completed within 1 year. Okay, perfect. Okay, let's keep going. I just want to get all the key terms out of the way first, okay? Okay, then we have partial performance. So if let's say we bought a property, right? A fixer-upper property. So let's take a look at fixer-upper property for sale, Fort Lauderdale, for example, right? Let's take a look at a fixer-upper here. So we'll click on the ad. So you see here we have a home. Let's say we have we purchase a home here for 599,000, right? A home like this. All right, Fort Lauderdale, pretty standard home in Florida. Let's say we decided to renovate the home, put money into it, and then we're going to flip the home. So let's say we enter into a contract with the original seller saying, hey, we're going to renovate the home. We're going to do this as constitution for selling it. So let's say we'll do that, for example. Under partial performance, if we've paid any portion of the sale price, so let's say we paid $80,000 already, or let's say we began to improve the house or took possession of it. So let's say we make the purchase, we sign the contract, and we start renovating the house. If we've done any of that, the contract's partially performed, and this will prove the contract in our favor. So let's say they wanted the house back after we started renovating it in order to flip it and sell it for a profit. They're not going to be able to do that under the partial performance exception. And then we know what a promissory estoppel is already. So, do you can put it in the chat box here. What's the definition of promissory estoppel that we went over? I'll give you guys some time. Just put it in the chat box. If you guys don't know, let me know. It's okay. Okay, you forgot. I'll give you guys one more minute. Okay. Okay, time's almost up. Okay. Once it hits 35 on my screen, I'm gonna. Okay, so promissory estoppel. Right, let's go back. Promissory estoppel, it's a legal enforcement, otherwise unenforceable contract due to a party's detrimental reliance. So you guys remember yesterday with the example, if you got a job offer, you started moving, you signed a lease on a new apartment in the plate near the workplace, and then they say it's no longer available, even though they promised it to you, that would be promissory estoppel. Okay. And then we also have the parole evidence rule. So this means that oral evidence of an agreement is indispensable if it is made before or at the same time as a writing that the parties intend to be complete and final version of their agreement. So the parole means speech or words in this case. So let's say, for example, we had said it while we were doing the writing. So let's say we did the terms in writing, but let's say we said to the wallet company, hey, can you also give us data as well? If we did not include that in the contract, but we promised to do it verbally, we wouldn't be able to do it due to the parole evidence rule. So if we added that to the agreement, but we didn't put it into the written contract, due to the parole evidence rule, we wouldn't be able to fulfill it. Okay. We also have a merger clause. So all this means is that it signals to the judges that a written contract is intended to be the final complete statement of the agreement. So it will also blend other agreements into the final agreement. So let's say, for example, we come up, maybe we do two different contracts, one for data and then one for financial purposes. And let's say we put a merger clause in to merge the two together to create one contract. We could do something like that. So that would be an example of a merger clause. So if we had a dispute regarding the contract, and we wanted to know what the final statement was, the merger clause would make it a lot easier. Okay. So we also have a condition precedent. So a condition precedent is basically all it is it's when a contract is going to be ratified on the condition of something else happening. So let's say, for example, we say if the wallets do not provide high quality, we have the right to void the contract. That would be a condition precedent. Or let's say, for example, we're working with a company that repairs the inventory. Let's say we have broken inventory in the Walmart and we sign a contract with them saying, hey, this contract is valid if our inventory gets broken over a certain amount. So that would be a condition precedent. Okay. Let's keep going. Okay, so we also have integrated contracts. So all these they are written contracts that are intended to be the complete and final representation of the parties' agreement. So basically, this is like the final say, like, hey, this contract, this is an integrated contract. Whatever you might say beforehand, if it's not in writing and in the contract we had done, it is inadmissible. So let's say we did the wallets, right? So we agree for $2,000 a month for Walmart to pay our business, and let's say they wanted data as well, and they didn't put it in the contract. If the contract is integrated, that would not be admissible anymore due to the parole evidence rule and also the fact that the contract's integrated. Okay, so that is going to wrap up this chapter. And I'll go back to some of these things, some of these sections here, and go over them. But I want to get the key terms done first. Okay. Okay, then we also have third party rights to contracts. So we have two different types of people in a contract. We have an obliger and we have an obligee. So the obliger is the company that's going to do something. So let's say the obliger is our wallet company. So we are going to send Walmart 2,000. We're going to send Walmart a thousand wallets a month in exchange for a payment of $2,000 a month. So we are the obliger. We're going to do something for Walmart, send wallets over to them, and Walmart is going to receive our wallets. So Walmart would be the obligee, and we would be the obliger. Now we also have an assignment. So that occurs when you transfer your rights to receive something under contract. So let's say, for example, we agree to give a loan to a car loan to Steve for $6,000. And let's say I assign the right for Steve's payment to be granted to to my friend Scott. So let's say I give him $6,000 for a car, and I assign the right to receive the money for Scott. So that would be an example of assignment. So I would be the assigner. I would transfer the right over to Scott, and then the assignee would be. So once we do that, we legally give up all rights to collect the money. So let's say we want to get the money. Once we do that, we cannot collect any part of the principal and interest for that car loan. Okay. Let's keep going. Okay, let's keep going. So we also have the first assignment and time rule. So all this means is the first party that's granted the assignment is given the right to the contract. So let's say, for example, I'm trying to come up with a good example. So if we transfer two or more parties to the same right, so let's say I assign Scott to be able to receive the payment, right? But let's say I also assign Tim to receive the payment. Whoever I did it for first is going to receive the payment if we assign two or more parties. And then we also have the English rule. So that means it's basically a game of musical chairs. Whoever gets it first gets it. So let's say I sent the offer to Scott first, but Tim accepted it and became the assignee faster than he did. Under the English rule, he would get it. So the difference between first assignment and time means the first that receives it gets it. The English rule means that the first that accepts it gets it. So one of them has to give the notice. So for the English rule, if they give the assignee the notice of assignment, they'll get it. They don't have to be the one that receives it first. For the first assignment in time, if they receive the assignment, that means they get it. That way there's no confusion. Okay. So we also have a delegation. So a delegation is when they transfer duty to perform to a third party. If you guys ever heard of the term delegating, it means to give a task to someone else. So the delegator, let's say I want to delegate posting on social media to a marketing company. So let's say I get into a contract. So I delegate my duty to perform that. Or let's say, for example, I have an example. So Google Domains was purchased by Squarespace, right? So now Google Domains was the delegator, and they transferred the duty to perform their services to the third party, which is Squarespace, which is the delegatee, right? They might not have been part of the original contract with their customers, but if they update the contract and have everyone agree to it, then that would be okay. So let's say Google Domain, they get bought out by Squarespace. Squarespace would be the delegatee, and Google Domains would be the delegator. Okay. And then we also have a third party beneficiary. So all this is when this basically is an intended beneficiary. So let's say, for example, we enter into a contract, right? For myself, let's say I own a trust fund, and I own a trust fund, and then let's say I own a stock account in which the beneficiary is my child. So it's created when two parties enter a contract with the purpose of benefiting a third party. So let's say at the age of 18 years old, my child can access the fund. So that would be an example of my child being a third party beneficiary. And then we also have an intended beneficiary. So that's a third party to a contract whom the contracting parties intend to benefit directly. So that would actually be a better example there. So let's say an intended beneficiary, let's say I make my child be able to access that stock fund when they turn 18 years old. So that would make them an intended beneficiary. Okay. So we also have a promisor and a promisee. So the promisor is a party that makes a promise that benefits a third party. So let's go back to the wallet example. So we're going to promise Walmart to deliver them 1,000 units a month. Walmart will owe us a certain payment per month, so $2,000 a month. So Walmart is the promisee because they're going to owe us something in exchange. The promisor is us because we are going to make a promise to deliver them the inventory. Or let's say, for example, we have a third party beneficiary. So let's say we have a debt. So let's say, for example, I agree to pay my niece's credit card debt. So let's say she's $15,000 of credit card debt. I agree to pay it. The third party beneficiary is going to be the credit card company. Or let's say I agree to pay my parents' mortgage off. The bank will be the third party beneficiary. So they don't have to directly exclaim who it is, but it can be implied that they'll benefit in some way. It's typically in regards to debt payments. Okay, let's keep going. So that gets us into creditor beneficiary. So let's say, for example, Alex agrees to pay the debt of Marissa. The credit card company is a creditor beneficiary. So if you guys remember, can you guys type in what a creditor is? I'll give you guys 2 minutes to type it in, what a creditor is. Give you guys around 2 minutes. Type in creditor. Okay, good. I'm gonna give everyone some time. I'll give you guys 1 more minute. Okay, yeah. Okay, yeah. So yep, that's correct. So Trey and Jaden, you're right. So it is someone that, yeah, so someone's gonna lend out credit or someone that's owed money. So let's say this house, for example, the house I'm in right now, there's a mortgage out on this house. So the creditor is the bank. So for example, the house that I'm in right now, JP, I believe Chase Bank holds the mortgage for it. So Chase Bank is a creditor, and then my family and whoever signed on the loan. So let's say it was myself, for example, I would be the debtor. So the creditor is the person that lends the money and is entitled by contract to receive the monies, principal plus interest for the mortgage. And then the debtor is going to be whoever signed off on the mortgage or whoever signed the guarantee. So that's correct. That's what a creditor is. Okay. Okay. I want to ask a couple questions. Okay. So let's do that real quick. All right. Creditor beneficiary. Okay. And then we also have a Donnie beneficiary. So all this is, it's a third party that's going to benefit from a contract in which someone gives a gift. So typically it's going to be a life insurance policy. So let's say, for example, if I die, my two kids and my wife will receive a $3 million life insurance payout. So that would make them a Donnie beneficiary. So we also have a vesting of rights. So in order for a vest to occur, so although an intended beneficiary can enforce the beneficiary's rights to a contract, the beneficiary cannot do so until the beneficiary's rights to the contract vest or mature so that the beneficiary legally can act on them. So let's say, for example, we have a trust fund. This will be common in here. And let's say my kids can access the trust fund when I die. So let's say I die at 95 years old and my kids are 38. Let's say that, for example. And my kids, so let's say we did it in the contract vest will allow them, as soon as I die, to be able to access the trust fund. So that would be an example of a vest. It's basically when the parties can get the benefit, the certain time period in which the parties can get the benefit. So very common with life insurance. Let's say I die and my family, because of the contract vest, they can receive the life insurance payout. Okay. And then we also have an incidental beneficiary. So let's say, for example, I have a house here, right? And I want to build a new fence. My neighbor will benefit from the fence, even though they did not pay for it, if that makes sense. So if I want to build a new fence in my backyard, and let's say it's better than the ones we already have, my neighbor would be an incidental beneficiary. Or let's say, for example, we decided to repaint a bunch of houses in the area, and as a result, because the houses look more lucrative, the value of the properties goes up for someone that might not have repainted their home. So that would be an incidental beneficiary. It's where some type of contract or obligation happens and it benefits someone that was not intended to be benefited. Now, let's say the property prices go down and we want to sue the company that was painting all the houses. Well, we can't do that because we don't have a right to enforce the contract because we never entered into one to begin with. Okay. Okay, so that would be what? I'm just trying to think of the week. So we did 13, 14, and then 15, 16, 17. I do 18, 19, 20. And then I do 32 and 50. Today is Wednesday. And then, okay. So I'm going to go through chapter 20. The reason why on Friday I want to do a full over review of everything. So I'm just going to go ahead and do chapter 20. Okay. So we have discharge and remedies. All right. So this will be our last chapter that we cover, and then I'm going to go into some of the more specifics. So we have conditional contracts. So these are condition. So basically, all these is they are contracts that contain conditions in which obligations can be performed. So let's say, for example, we say, hey, if we have AC problems, we enter a contract, and with this AC contractor to fix our AC, we enter into a contract with them. So that would be a conditional contract. Now we also have a condition precedent. So if a occurs, allows for the duty to arise. So let's say we enter into a contract with the attorney saying, hey, if we get sued by our landlord, we're under to be able to use you as our attorney. So that would be a condition precedent. So we also have a condition subsequent. So precedent means something that's preceding. Try to think about it like that. It means something must happen in order for the contract obligations to matter. For a condition subsequent, it means that the obligations of the parties might be terminated once the jobs is complete. So let's say, for example, we sign a lease on an apartment for 2 years, but let's say we're in the National Guard and we have to go within a year and we're not going to live in an apartment here. We can create a condition subsequent in which we don't have to pay for rent for the year while we're at the National Guard base. So that would be a condition subsequent. So the precedent exists when a condition must occur before the duty to perform arises. The condition subsequent has to happen during the occurrence of the condition. That's going to extinguish a party's duty to perform. So then we also have concurrent conditions. All that is when each party's performance is conditioned on the performance of another. So let's say we pay Walmart for the wallets. Walmart pays us for the wallets. We give Walmart the wallets. That's concurrent conditions. Both of our performances, Walmart's obligation to pay us and our obligation to deliver the inventory, that would be concurrent conditions. So we also have express conditions. So these are explicitly stated in the contract and are usually preceded by words such as condition on, if, provided that, or when. So let's say, for example, we put, I'm trying to think of a good example or condition on. If actually, you know what? Let me ask one of you guys. What would be a good example of express conditions in a contract? You could type in the chat or speak in the microphone, either or. I want to get some ideas. And if you guys don't know, just let me know. Oh, I had do that.
What was the question again?
The question was, I would like to give an example of express conditions. So here is the definitions on the screen right here.
Would it be like signing, or I guess trying to move into a fresh lease without making the deposit first?
Yes.
Or like
So, yep.
getting a
No, that's
lease
a good one.
Or making a deposit?
Yeah. So let's say we make the deposit, for example. So let's say, we go ahead and say, if you decide, let's say, for example, we put in money for the closing costs, right? So let's say, we're going to put $4,000 in, for the closing costs of the home, on condition on that we're able to close. So, and the condition is that if you are not able to close on the home, you will be refunded the $4,000. So let's say we put $4,000 in for the closing costs, to purchase a home, for the loan costs, whatever referral fee, broker fee. The express condition would be, on condition that the home is sold, the payment will remain. If on the condition that you do not get the home and not are able to purchase the home, the money will be refunded. So that would be an express condition. Okay. Okay. And then we also have an implied condition. So those are ones that are not explicitly stated, but are inferred from the nature and language of the contract. So let's say, for example, we want to get our house renovated. An implied condition of the contract is for the contractor to be able to enter our home. And they wouldn't be allowed to be charged with trespassing. So, for example, if we wanted someone to paint the inside of our house, they have the implied condition to be able to enter the house without getting charged with trespassing or burglary. Okay. Now we also have a tender. So let's say, for example, we sign a contract to get our house painted, but at the last second we decide to back out after it's signed. We can do a tender. So if if they come say, hey, I don't want it anymore, even though we signed the contract, the painter is now discharged of their duties under the contract. So the guy can't sue, say, hey, they didn't paint my house. What they could do, the painting company can do a tender in which they are void of all responsibility. So we have two different types of performance. We have complete performance and substantial performance. So complete performance means everything in the contract has been carried out perfectly. The more common one, though, is substantial performance. So let's say we completed 95% of the work, but we forgot one thing. while painting the house. Let's say that the person that we did it for wants to sue. It's a strong chance they won't be able to win because we completed nearly all the terms of the agreement. And we can see here, we made an honest effort to complete all the terms and no willful departure from the terms of the agreement. So let's say we completed most of the items in the contract that we put in, pretty much all of the obligations. Maybe we missed one or two. If we made a genuine effort to do the ones that we did not complete, and we just weren't able to do it for whatever reason, that would fall under substantial performance. Okay. And then we also have a material breach. So this is what can occur. So a material breach will discharge a non-breaching party from their obligations under the contract. So let's say a party unjustifiably fails to substantially perform their obligations. So let's say when they come and paint the house and we refuse to pay them, that's a material breach of contract because we are for no reason. Let's say they did complete performance right on the house. Let's say they painted the inside of the house. That would be a material breach because we are now fulfilling our end of the contract to make a payment. So that would be a material breach. Okay. Okay, so we have novation. So all this means we want to replace one of the parties with another. So let's say our company gets bought out by a larger painting company during our project. So let's say we get bought out. Let's say we're Star Painting Corporation and we get bought out by Best Painters LLC. So Best Painters LLC will now replace the other corporation because the other corporation was bought out. So we would do as a novation. So now the company that bought out the company that was doing the job will now be under the contract. So that would be novation. And now we have two different types of impossibility. So we have objective impossibility and subjective impossibility. Objective impossibility means that it's not possible to lawfully carry out one's contractual obligations. So let's say we want to be able to, I don't know, let's say we want to distribute the items, but we want to do it with an illegal, but let's say the trucks we have are stolen. That would be objective impossibility because we can't complete the contract. So let's say we wanted to deliver the wallets, but the trucks that we're delivering the wallets in are stolen or we obtained them illegally. We can't carry out that contractual obligation. So that's going to fall under objective impossibility. Subjective impossibility means it would be very difficult to carry out the contract. So let's say Walmart, let's say our warehouse is 500 miles away from Walmart. And let's say Walmart requires that we make a delivery every single hour. That would be subjective impossibility because it would be very difficult to carry out the contract. Okay. Okay. And then we also have monetary damages. So those can fall under compensatory, which we remember. Do you guys remember from the first chapter? Can anyone type in what compensatory damages are? I'll give you guys a minute to do so. You can also say in the microphone too, if that's easier. I'll wait one more minute. Okay, so compensatory damages is basically when someone loses money or they lose something of value. They want to file a lawsuit in order to regain the position that they were in. So you see here, so it's designed to put the plaintiff in the position that he or she would have been had the contract been fully performed. So let's say we have a workers' comp case, and let's say the company did not have workers' compensation insurance, which, by the way, if you have W-2 employees in your business, you're pretty much required to have it. But let's say we lost, or let's say, for example, we got injured at this restaurant and we want to sue the restaurant for negligence, and we seek compensatory damages because we lost wages because we didn't get paid time off for work. We could sue in order to recover our lost wages and also to pay for our medical bills. So that would be under compensatory damages. Okay. Then we also have consequential or special damages. So these are damages that are foreseeable that result from special facts and circumstances. So let's say, I'm trying to think of a good example. It must be within the contemplation of parties at the time the breach occurs. I want to do it one more time. Guys, give me an example of a consequential damage. It could be in any situation. Doesn't even have to be law related. I'll give you guys 1 minute to think about it.
I guess like for me, let's say I'm at work and I'm trying to serve out a bunch of drinks, and then my boss told me don't serve out like 16 beers one time, and I'm like, okay, I'll do it anyways, and I slip and fall, and then all them just drop. I guess that'd be a consequential damage, possibly.
That could be good. So let's say, for example, someone at your place say, "Hey, you got to serve these beers," and let's say there are way too many there, and the beers spill, you slip and fall and hit your head. Um, if you were not able to, if you could sue for damages there, but let's say the beer tap was broken, and the company that was hired that's supposed to be hired to do so did not come, and as a result, the bar lost a significant amount of money because they didn't have alcohol on tap. So that could be an example of consequential damages. So because you did not come in and fix this, we lost money. So that could go fall under consequential damages. And then we also have punitive damages. So they're basically to punish the defendant. If you guys remember from the previous chapters, we went over it. Basically, I'll give you guys a little refresher in tort law. It's basically, for example, let's say, hey, you guys remember the segways blowing up? It was a long time ago, 2015, 2016. So the segways would blow up. So under punitive damages, we could prevent the Segway company from selling those model of Segways ever again. They have to design a whole new model. So that could be punitive damages. And then we could have nominal damages. It's really just getting maybe $1 or $5, but it's to signify that the plaintiff was wronged by the defendant. I think it's pretty straightforward. Nominal means really small. And then we have liquidated damages. So all this means is that the damages are in a fixed amount. So you remember from liquidated debt how there's no dispute about how much is owed. It's kind of the same thing with liquidated damages. It's a fixed amount or a formula that will say the exact amount of how much money is going to be due in the lawsuit. So that's what liquidated damages are. All right. And then we also have, let's keep going down. We have rescission and restitution. So rescission, think of when you rescind something. When you rescind an email, the word rescind means to take away. So to rescind or rescission means to terminate a contract. So let's say we're in a lawsuit, and let's say we get injured really bad and we say, you know what, we want to back out of the contract. We can, under rescission, we could terminate the contract. And then restitution, let's say because we got injured, let's say I'm the owner of the business, I had to be out, and as the owner of the business, let's say I don't get PTO, pay time off, I can get restitution for the lost wages. Or better yet, let's say, for example, I gave them a piece of equipment and I got injured on the equipment they gave me, they could return the property for me. Once once the contract falls under rescission. Okay. This chapter you guys are gonna have to study pretty extensively, and I'll make sure to do private sessions for this too. But this one's probably got the most material. The insurance law has a lot of material as well. That's why I did only 2 chapters for the next couple sessions this week. We also have a specific performance. So all this means is an order requiring the breaching party to fulfill the terms of the agreement. So it's pretty much, hey, you have to complete this, this, and this in this way, and you have to legally oblige to it. So that's specific performance. And then we also have an injunction. So it's going to prevent someone from doing something, prohibiting a person from doing something. So you guys ever seen with an NFL player how they might put something in their contract where they can't play another sport during the offseason because they're worried they could get injured? Well, that's an injunction. So that's going to force them to prohibit from doing something. So that would be an example there. Okay, so that's that. I'm going to ask you guys a couple questions about some of the terms. Before I do that, though, does anyone have any questions regarding any specific chapter, any particular concept? Now's the time to ask. Okay. Seems like no one really needs. Okay, let's go to 18. So I'm going to ask you guys some of the definitions. So let's go over it. Okay. Okay, we did 17, 18. Okay, let's go down. Okay, so can you guys tell me? It could either be in the chat or in the messages, or you could say it on the microphone. Can you tell me the 3 reasons why there's a statute of frauds enacted for contracts? I'll give you a hint. I'll give you one of them. One of the main reasons is to prevent falsified oral statements to be made. So one of them is falsified oral statements. Can you guys type in the other 2 or say it in the microphone? Either or. I'll give you guys 2 minutes to figure it out. Good. That's one of them. What's the last one, Victoria? Good. So we need to have reliable evidence, prevent parties. So let's go back to it. There's a lot here. Reliable evidence, prove specific terms, and to prevent parties into contracts in which they don't agree. Perfect. Okay, good job, guys. All right, so I'm also going to ask one more here. Okay, we went
Can you
over
just go over the parole evidence rule again,
Sure.
please?
first. So the parole evidence rule, right? So it's basically if someone makes an oral agreement or they say something orally before the contract was put into writing and agreed upon, it means that the evidence is now indismissible. So let's say, hey, they agreed to give us this amount of money, but then we see the contract that doesn't say that. Due to the parole evidence rule, we that evidence that they say, hey, they owed us more money would be indismissible. So that's the parole evidence rule. So, and the reason why this is done is so that there's no evidence that could contradict what the contract says, because the written form is what we're going to be looking for if the contract is even in writing. So if we said, hey, they agreed to pay me $4,000 for the wallets instead of $2,000, but let's say in the contract it's $2,000, the parole evidence rule will prevent the court from saying, hey, maybe they did agree to pay $4,000 when they didn't. Let's say Walmart is lying. So that would be the parole evidence rule. That's why it's enacted, to prevent evidence that will substantially contradict the agreement in written form. Okay. All right, I'm going to go to the next chapter. Okay, can you guys tell me the difference between the first time and assignment rule and the English rule?
The first assignment in time rule gives the right to the first party granted the assignment, and the English rule is basically like first come, first serve. Whoever gets it first gets it.
Okay, good. Give me an example.
I don't know. I'd have to think about it.
It's okay. Take your time.
I guess it would be like making an offer to two different, for the English rule, making an offer to two different companies. So like Walmart, for example, if they were to say, well, we want a Hydro Flask or we want a Stanley or something like that, they send an offer to both companies, and whoever accepts that offer first gets the offer with Walmart.
Yep. So if they accept it first, but under the first assignment in time rule, it's whoever receives it first. So if Walmart sent, let's say we have Stanley and we have, I don't know, Gold cup manufacturers. Let's say they send it to Gold cup manufacturers first. If the first assignment in time rule applies within that jurisdiction, the gold cup manufacturers gets the contract with Walmart. But if it's under the English rule in that jurisdiction, and let's say Stanley accepts it before Gold does, that's going to fall under the English rule. Good job. Perfect. And what is the difference between an assignee? Better yet, let's just do, what is an assignment? What would be a good example of an assignment? You could type it in, say in the microphone, wherever you can get the information across. Second. Trying to sucks that I can't minimize. Good. Yep. What would be an example? I give you a hint. This is really good in terms of lending and mortgage law. So if you have something regarding loans in particular, it's really good. So I give you guys an example. Let's say we get a loan from TD Bank, and then TD Bank sells my loan on the secondary market, which what banks will do is they'll sell the loan on the to big investment groups like Raymond James and JP Morgan Chase. So these investment banks will buy up the secondary market, what we call mortgage-backed securities. That's one of the reasons why the 2008 crash happened, because a lot of people bought bad mortgages, which people couldn't pay, and and everything exploded. But let's say, for example, TD Bank, they sell my loan on the secondary market. Now they are handing over their rights, even though they lent the money, the rights to receive the payment now go to the investment bank in their fund. So that would be an example of when someone sells my mortgage on the secondary market. Okay, and then I'll do one more question. Okay, and I'm going to do it for the last chapter, and then we'll go over more tomorrow. Okay. Okay, so can someone tell me an example? Let's do consequential, compensatory, complete. Okay, can someone tell me the difference between complete performance and a where's the other performance? There's complete performance, and then there is. All right, can someone tell me the difference between a complete performance and substantial performance in a contract? Give you guys 2 minutes to figure it out. Think about the wording. Complete means it's all done. Substantial means most.
So complete would be like if all the terms of the contract would be perfectly performed, and then substantial would be if like not like most of them will be like performed, or some of them will be performed. I don't know.
Yep. No, that's right. Perfect. That's all it is. Okay. So if you guys, I know that this was a lot to swallow here. Let me just stop the recording real quick. So we are done here. Okay, guys. So that's it for today. Let me just stop the recording real quick. Okay.